Swayam Prabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana from Faculty of Law, University of Delhi. I, along with Professor Dr. Vageshwari Deshwal, Faculty of Law, University of Delhi, would be discussing procedural criminal law contained in Bharatiya Nagarik Suraksha Sanhita 2023. Today in this session, we shall deal with complaints to the magistrates and the commencement of proceedings. We shall be dealing with chapter 16 BNSS, which deals with complaints to magistrate, and then chapter 17 which deals with commencement of proceedings before magistrate, how the proceedings shall be taken up. And when we are saying magistrate here, it means judicial magistrate. Now, to start with, most of us would be having the idea that if a crime happens, then only redressal or only agencies to which we can go is police, and that we would file an FIR before the police. But that is not the complete picture. If we see section 223 BNSS, then not only that we can go to the police as we generally know, but also that we can go to the court of magistrate complaining about the crime. If we look at section 210, it says any magistrate first class or magistrate second class, if he is specially empowered in this behalf, so magistrate first class or any magistrate second class specially empowered in this behalf, first class need not to be empowered, second class need to be empowered. So, if there is any such magistrate, he may take cognizance of any offence upon receiving a complaint, upon receiving a police report, or upon other information. Other information means information by a third person or even magistrate's own information, that he can take cognizance. What does cognizance mean? Cognizance means that a criminal case formally enters the judicial redressal system, as in the court. Now, it may enter in three ways. This way, everybody knows that a crime happens, a crime is committed, and then the victim would go to police station, file an FIR, police would conduct investigation, file a challan or charge sheet. This challan, charge sheet or police report is contemplated here that the magistrate, police cannot punish on its own. What police can do is that it would register an FIR and conduct an investigation and then file the challan before the magistrate. It is the magistrate that would punish the accused if found guilty. So, ultimately, the matter which the police collects during investigation would come in the form of challan before the magistrate. So, we can go straight to the magistrate also. I mean, if police can take a challan to the magistrate in relation to some crime, private person also has been empowered by law to straight away go to the judicial court and file a complaint, and magistrate may take cognizance upon that and then may try the accused and then punish him. So, subsequent proceeding would be same. The trial would be different. There would be procedural difference between the trial held on a complaint and the trial held on a police report. But then the ultimate result of that would be conviction, acquittal, as would happen in both cases. That is same. And then it says that cognizance may be taken upon other information, as in, as I said, by third person or by magistrate himself. So, what I want to highlight here is that a private person can go straight away to the court and may ask the person presiding there that you take cognizance of my complaint which is about a crime. So, say A hurts B. B can either go to police station or can go to a court asking the magistrate to take cognizance of his offence. The same thing police would do. If B goes to police station, police would investigate the case, make a challan, and again would come to the court, and the court then would take cognizance upon that. So, whichever way you go, the court would take cognizance if it finds substance in the police report or in your complaint and take cognizance. As I said, then there may be some procedural differences, but then it would ultimately lead to conviction or acquittal of the person accused in your complaint or in the police report. Now, let us see what complaint means. Section 2H says, BNSS, any allegation made orally or in writing. So, you can go to the court and even orally speak before the magistrate that some such crime has been committed against you, or that you can give it in writing to him. Magistrate here means what magistrate? Judicial magistrate. It is not DMSDM, no executive magistrate. It is only the judicial magistrate. Again, why? Because only a judicial magistrate can convict and sentence somebody. An executive magistrate may stop somebody from committing violence, may take preventive action that somebody would be stopped from committing a crime. But then once crime is committed, it is only a judicial magistrate that can try the person accused and may sentence, convict and sentence him. This cannot be done by, as I said, by a DMSDM executive magistrate. So, somebody going to a judicial magistrate, making any allegation orally or in writing, with a view to take action under this Sanhita, that is to take cognizance upon his complaint and try it further. And what does he say? He says some person, whether known or unknown, I mean it is not required if the accused person is known only, has committed an offence. So, that is how we understand a complaint. Any allegation made orally or in writing to a judicial magistrate with a view to that he would take cognizance of that complaint and that some person has committed an offence. And then it specifically says that it does not include a police report. Police report is not a complaint. Police reports are taken cognizance of separately. I mean, if police is taking a challan before the magistrate, judicial magistrate, it would not be a complaint filed by the police. So, that for the sake of clarification that it has been given that a police report shall not be deemed to be a complaint. Why? Because as I said earlier, there would be some procedural differences between a case filed on a complaint and a case filed on a challan. So, for that purpose, the difference has been maintained here also. It is not essential in such complaint that the names of the accused should be given, as we have seen. It is also not necessary that the complainant would be knowing law, as in he would be writing sections that such and such person committed such and such offense and that is punishable under such and such section of, say, BNS or some other law. So, sections also need not to be mentioned, but then the complaint must be verified. The complaint must be verified because the idea is that if somebody files a frivolous complaint before the court, now filing a frivolous complaint is itself a crime. So, if somebody does a crime and somebody files a frivolous complaint by somebody else's name. So, Ramesh files a complaint in Suresh's name and ultimately it is found to be a frivolous complaint. Then maybe that Suresh may be prosecuted for something that he has not done. So, it has been observed by Bombay High Court in Roy Joseph versus S.K. Tamisuddin, 2008, CRLJ 1509, that the complaint must be verified, signed and verified that he is the person that is filing this complaint, otherwise legal consequences may follow against a wrong person. There is one more significance of complaint. As I said, a private person can go to the court of judicial magistrate straight away and file a complaint. Also, that there are certain provisions in BNSS according to which a particular criminal proceeding can be filed only through complaint. I mean, police cannot file challan in those cases. So, those cases would be as provided by section 219 BNSS. It says that if the offense against marriage, say for example bigamy, then the crime can be taken cognizance of only on a complaint filed by the aggrieved person. Who shall be aggrieved? Of course, if husband remarries wife and vice versa. Also, if you look at section 222 BNSS, it says that if there is a crime of defamation, in a crime of defamation, police cannot file charge sheet. I mean, if police files charge sheet, that would be of no utility because the court cannot take cognizance of such charge sheet. Section 222 BNSS says that a offense of defamation can be taken cognizance of only on a complaint filed by the person aggrieved before the court. So, challan of filed by the police will not do. So, that is also the significance of a complaint. Now, let us see section 223. It says a magistrate having jurisdiction while taking cognizance of an offence on complaint. Now, who will be such magistrate having jurisdiction? It is any magistrate first class, as we have seen here, or any magistrate second class, but second class has to be specially empowered in that behalf. So, any magistrate first class can take cognizance of an offence on complaint, and of course, any magistrate second class specially empowered can take cognizance of an offence on complaint, and then what would he do? He shall examine upon oath the complainant and the witnesses present, if any. So, witnesses present, if any. Complainant shall be examined mandatorily, shall examine upon oath the complainant and the witness present, if any. And the substance of such examination shall be reduced to writing signed by complainant and the witnesses, again if any, and also by the magistrate. So, if somebody files a complaint before the court as a matter of taking cognizance, it says while taking cognizance. So, as a first step that it would take cognizance and contemporaneously to the taking of cognizance, that examination of the complainant and of the witnesses present, if any, shall be conducted by the court, signed, etc. And then it says, provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. This is a new provision added in BNSS. It was not earlier in CRPC 1973. Earlier, it was as if the accused does not have any locus to take part in these proceedings until unless he is specifically called under section 204, that the court finds substance in the complaint and calls the accused in the court. Before that, the accused will not have any locus to take part in the proceedings. But here, even at the initial stage, BNSS 223, even at the initial stage, the court has to give an opportunity to the accused that he shall be heard in the court before proceeding further. Then it says, provided further that when the complaint is made in writing, so when the complaint is made in writing, so as we may recall that I said complaint can be made orally or in writing. So if it is made in writing, the magistrate need not to examine the complainant and the witnesses if the complainant is a public servant acting in discharge of his official duties, or a court has made the complaint. So if a public servant or a court makes a complaint, they need not to be examined in the court. The idea is that they are responsible officers, and if they are making a written complaint, then it must be holding some substance and they need not to be examined in that connection. Then it says, or if the magistrate makes over the case for inquiry or trial to another magistrate under section 212. As I said in some other session, that this section is an exceptional section here. Earlier in old law, it was 192, section 192 CRPC. So generally, the court which takes cognizance, generally speaking, would try the case, although that may not be true in many cases, but then in a general sense that the court which would be taking cognizance would be trying the cases. But then section 192 says that CJM or any JMIC, JM first class, specially empowered in this behalf, may take cognizance and send the case for trial to some other court. So this generally does not happen. I mean, courts do not do in that manner, as in taking cognizance and sending the case to some other court. But then section 192 gives power to these particular courts that they can do that. Now, proviso B says, as I said, if the magistrate, such magistrate as in CJM or JMIC specially empowered in that behalf, makes over the case for inquiry trial to another magistrate under section 212, the magistrate sending the case, as in making over the case, as in that CJM or JMIC who is specially empowered in that behalf, that magistrate need not to examine the complainant and the witnesses. So it is talking about the sending magistrate, the one who is making over the case to another. This sending magistrate is being discussed here, that he may take cognizance and without examining the complainant witnesses may send the case to the other magistrate. That power is there under section 212 as I discussed, and the proviso says that it can be done without examining the complainant, the witnesses. Then it says provided also that if the magistrate makes over the case to another magistrate under section 212 again, after examining the complainant and the witnesses, the latter need not to re-examine them. So what does it mean? It means if the sending magistrate did not examine the complainant and the witnesses, then the receiving magistrate would examine them. And if the sending magistrate had already examined them, then the receiving magistrate need not to examine them. So the duplication of examination has been avoided here. That is the purpose of these provisions. Now, Section 223 further says that a magistrate shall not take cognizance on a complaint against a public servant. So, earlier we were contemplating a situation where a public servant is a complainant, he is making a complaint. Here we are discussing a situation where a complaint is against a public servant. In that case, of course, complaint against him while he was acting, as in complaining about his act that was committed in course of discharge of his official duties, not in his personal capacity. If such is the situation, then it says that magistrate shall not take cognizance unless such public servant is given an opportunity to explain the incident. So, if he has any justification, etc., he may be given a chance, he would be given an occasion to communicate it to the court, and a report containing facts and circumstances of the incident from the office superior of such public servant is received. So, the judicial magistrate would be considering these matters before deciding whether to take cognizance on that complaint or not. Section 224 says that when a complaint is made to a magistrate not competent to take cognizance of a case, then of course, if such thing happens, if it is in writing, this complaint must be returned for presentation to the proper court. It goes without saying. The court would return the complaint, and if the complaint is not in writing, the court would orally direct the complainant to the proper court. So, these are obvious provisions. Next, now this is a very important idea, postponement of issue of process. Now, actually, when a complaint is taken cognizance of, that we have already seen in section 200, the next crucial step would be, the next major step would be calling the accused in the court. Now, complainant is in the court, we have to have the accused in the court as well. These sections I am quoting from CRPC 1973 with analogous provisions in new CRPC 2023 as sections 223 and 227 respectively. Now, if the magistrate taking cognizance on complaint feels that there are adequate grounds that have been proved by complaint, if it is in writing, by other material produced together with the complaint, if any, by the examination of witnesses, etc., it feels satisfied, then it may straight away call the accused under section 204. But if the court is not ready to, or the court does not feel satisfied, I mean the court is in a twilight zone, is in a doubt whether to call accused or not, then in that case, this section would be of vital importance, which says that if the court is in doubt in this manner, in this context, then it may postpone the issue of process. Ultimately, we are moving towards this direction, that we call accused in the court. So, postpone that idea for a while and let us do some more inquiry. Let us conduct some more inquiry, or let us ask the police to investigate in the matter. This investigation here is not that investigation which is contemplated after an FIR and then a challan is filed. This investigation is not that investigation. This investigation is a narrow investigation, just to make sure that there are adequate grounds that the accused may be called in the court. So, this step is designed to remove the hesitation in the mind of magistrate to issue process. It should not be made a full dress trial of the case. So, no detailed discussion on merits or demerits of evidence need to be there. It is only to see the probability apparent on the face of the case, and based on that probability that somebody would be called in the court under section 204 as accused. So, it is a prima facie satisfaction that the magistrate need to have before calling somebody in the court as an accused under section 204, and if even that prima facie satisfaction is missed, then section 225 may be put into action. Now, it says any magistrate on receipt of a complaint of an offence which is authorized to take cognizance, and as I said, any JMIC, any JM second class specially empowered, which has been made over to him under section 212. We have already discussed somebody taking cognizance, sending it to somebody. So, this magistrate who has taken cognizance or the case has been sent to him may, if he thinks fit, and shall be in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction. Now, you see, if A makes a complaint against B, A is in Delhi, B is in Mumbai, A goes to a Delhi court, makes a complaint against B. In this case, this postponement of issue of process is mandatory. Had it been such a situation where both A and B reside in Delhi, then it would have been discretion of the court to hold this inquiry or not. But then if B is, as in the accused, is living in an area which is outside the local jurisdiction of this court, then this court has to postpone the issue of process and act according to this section. Postpone the issue of process and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit. If we see section 2H, we would come to know that investigation may be done by a police officer, or let me see it, which is the section. It is 2L, not 2H, 2L. So, investigation may be asked to be conducted by police officer or by any other person not being a magistrate. So, a private person may also be asked to conduct investigation. And as I said, this investigation would be different from an investigation which is conducted on the basis of an FIR. That is a general investigation. Police report is filed, challan is filed, wider investigation. Here, a narrow investigation is contemplated just on some points that the court would be requiring the police to file its finding on a certain issue or on few certain issues, so as to make up its mind whether to proceed further towards section 204. It is like in the old law, now it is section 227. Now, this step when the accused would be called in the court, in old law it was 204, now it is 227. So, whether to proceed towards 227 or not, that investigation would help. Then it says, provided that no such direction for investigation shall be made, no such investigation shall be made. So, the magistrate cannot ask the police to conduct investigation or any other person to conduct investigation where it appears to the magistrate that the offence complained of is triable exclusively by court of session. So, if the complaint relates to a session tribal case, say for example, if it relates to a murder is a session tribal case, then so in that case the magistrate cannot direct investigation, then in that case he would have to inquire it himself. It also then says, or where the complaint has not been made by a court, unless the complainant and the witnesses present, if any, have been examined on oath. So, only a court has been exempted here. If we compare it with the earlier slide, so where it has not been made by a court. So, say for example, it is made by a private person or even by a public servant, not being a court, then such investigation shall not be ordered unless such complaint and his witnesses present, if any, examined. Then it says that in session tribal cases, all his witnesses must be examined. Complainant must be asked to produce all such witnesses that he can produce or he would be desirous of producing. Then it says that if an investigation under subsection 1 made by a person not being a police officer, that is very much possible, then so such a person shall have for that investigation all the powers conferred by this law on an SHO except the power to arrest without warrant. So, such a private person would be investigating the case with all the powers, but except one power, that to arrest people, of course, in the context of that case. Then section 226 says that dismissal of complaint. It says that if after considering the statements on oath of the complainant and of the witnesses under section 225, as in the preceding section just that we discussed, that the magistrate is of the opinion that there is no sufficient ground for proceeding, he shall dismiss the complaint and record his reasons for doing so. So, what did we see till now? Anybody going to court making a complaint regarding a crime, court as in the magistrate, judicial magistrate examining the complainant and the witnesses, and if he is sure, he is not hesitant in forming prima facie opinion, calling the accused in court. If he has some hesitation, conducting an inquiry himself or an investigation by police or by some other person, and if he is sure then of existence of prima facie case, then issuing process, calling the accused in the court, and if he is not, if he is of the view that there is no prima facie case against the accused, then dismissing the complaint. Now, let us look at some judicial pronouncement upon the law that we have discussed. In A.R. Antule versus Ramdas Srinivas Nayak, AIR 1984, Supreme Court 718, the Supreme Court observed that it is not a condition precedent to the issue of process under the relevant section, earlier it was 204, now it is 227, that the court must hold an inquiry under section 202, old 225, the new one. So, it is not that it is necessary that the magistrate would hold an inquiry and then only would issue process. If under section 223 that the magistrate is of opinion that the accused may be called in the court, it cannot be said that a processual safeguard has been denied. That means 202 earlier, old law, 225 new law is not a mandatory process. If the magistrate otherwise is not hesitant in calling the accused in calling the person as an accused in the case, then he may not resort to 202 at all, 225 at all, and then it cannot be said that a safeguard from the accused has been taken away. Then Muhammad Yusuf versus Afaq Jahan case, AIR 2006, Supreme Court 705, the Supreme Court observed that the investigation under section 202 is, that is with a very narrow view to help the magistrate to decide whether or not there is prima facie ground for him to proceed and no further. Also, that it was observed that this investigation under section 202 is post cognizance, that the cognizance has been taken. So, the magistrate may have two options. if complaint is put before the magistrate may, without taking cognizance of the complaint, may order investigation, or after taking cognizance, again may order investigation, that is under section 225 that we have just discussed, 225. So, without taking cognizance and after taking cognizance. This without taking cognizance investigation is a full investigation. The police would register FIR and investigate the case and file a challan charge sheet before the court. This investigation, as I said, is a narrow one. No FIR, no investigation in a general sense, and no challan. Then this investigation, which I said that is without taking cognizance of the complaint, would be under section 175 BNSS. To be precise, 175(3). Earlier 156(3) CRPC 1973. Now, let us quickly move to other provisions. Then issue of process. This is something that we are discussing right from the beginning. That complaint, I mean, it is without any significance if the accused is not called to the court, because ultimately he is to be tried and punished for commission of crime. Now, this is something, some provision where the accused would be called in the court, and it is not only for those cases which have been instituted on complaint, but also for those cases wherein police report has been filed. Police report as in after FIR police report. FIR under section 173, then investigation, and then police report, challan in full sense. So, there also the accused is called under this section only. So, the idea of section 227 is that if the person is to be proceeded further, if the accused person is to be proceeded further on any which way possible, then he has to be called in the court under section 227 to proceed further. Now, the next step for where the proceeding would be going on now is to frame charge. So, cognizance would proceed towards process issuing. So, cognizance is taken with a view to issue process, and process then, once the process is issued, process means summons or warrants, and thereby the accused is called in the court. Once the accused comes in the court, further proceeding is for framing charge against him, Now, we are at this stage where that we are issuing process against the accused person, and as I said, it does not matter here whether the case was filed on complaint or filed on a FIR police report, FIR culminating in a police report. This is called case instituted on police report. This is called case instituted on complaint, or sometimes it is also called case instituted otherwise than on police report. It means that it is a case either instituted on a complaint or that the magistrate takes cognizance on his own information. Now, let us quickly see this section. It says, if in the opinion of a magistrate taking cognizance, there is sufficient ground as I said, prima facie satisfaction, no detailed analysis of merits and demerits of the evidence. That is to be seen. It should not be made as in a full dress trial or a mini trial, and for him the case appears to be a summons case or a warrant case. Warrant case means more than 2 years punishable. Summons case means all other cases. So, if it is a summons case, if it seems to be a summons case, he shall issue summons. If it is a warrant case, he may issue a warrant or he may issue summons for causing the accused to be brought as in arrest and bring him, or appear as in he himself appears, right? At a certain time, of course, at a certain time before such magistrate or some other magistrate having jurisdiction, etc. Now, it further says, no summon or warrant shall be issued until a list of prosecution witnesses has been filed. Then it says, in a proceeding instituted upon a com made in writing, every summon warrant issued under subsection 1 shall be accompanied by a copy of such complaint. Of course, the accused need to be apprised of the complaint against him. Then only he would come prepared. Then it says, when by any law for the time being, any process fees or other fees are payable, no process shall be issued until the fees are paid. So, if to call the accused in the court, for example, if there is any law that require that if process fees should be paid, then until such fees is paid, no process shall be issued, and if such fees are not paid within a reasonable time, the magistrate may dismiss the complaint even on this ground. Then it says, nothing in this section shall be deemed to affect the provision of section 1990 is what? It says that where the court may issue a summon, it may issue in that case a warrant in lieu of summon. So, even if it is a summons case, ideally the court must first issue summon, but then if it is of the view that the person would not come in the court on summons, then it may issue the warrant in lieu of summon, that is section 90. Then it says magistrate may dispense with personal attendance of accused. So, he may appear through advocate. Then section 2 to 9, special summon in cases of petty offences. Petty offences are, now here petty offences have been defined as those offences wherein any offence which is punishable only with fine. So, the offences which are punishable only with fine would be petty offences, and section 2 to 9 says that they may be tried summarily, and in that case special summons shall be sent. Those special summons would be asking the accused to come present personally or through advocate, or if he does not wish to come, then to send the amount of fine through post or some other means, and then it says that the amount of the fine specified in such summons shall not exceed 5,000 rupees. So, the idea is that the cases would be petty offences that may be tried summarily in the opinion of the magistrate. Petty offences are those offences which are punishable with fine only. The accused without coming to the court may send the amount of fine to the court, and such fine the court would specify in the summon itself, and such fine would not be exceeding 5,000 rupees. Then it says supply to accused copy of police report and other document. Now, section 230 is a case where the proceeding has been instituted on a police report. So, it has been preceded by an FIR investigation and the police filed a challan. Now, in that case, once the accused comes to the court, that you have called him to the court, you will give the material collected during the investigation. That is, the challan, a copy of challan has to be given to the accused. Of course, we are heading towards what? Towards framing of charge. Now, for framing of charge, he need to have some material to argue, to take part in the argument. He need to have some information about the case. So, here we are giving him a copy of challan, if the case of course has been instituted on a police report. If the case has been instituted not on a police report, that is otherwise than on police report, as in on complaint, say for example, then it says, and the offence is triable exclusively by the Court of Session. So, this is for on complaint and where it is triable by Court of Session. If it is triable by magistrate, then section 267 pre-charge evidence would take care of this. Here, if it is triable by Court of Session, then section 231 says that these documents must be provided to the accused so as to make him ready to face arguments on so as to enable him to argue on the charge. Now, next section is section 232 where the Court of Session, where the magistrate court commits a case to Court of Session, whether it is filed by police report, challan or on complaint. It sends the case to the Court of Session. And this section is where there is a complaint case and there is a police investigation going on parallelly in respect of same offence. So, a private person went to the court, filed a complaint in a murder case, say, for example, and in the same murder case, there has been an FIR investigation going on. Now, if this happens, what to do in that case? Section 233 says that if such thing happens and it is brought to the notice of magistrate that an investigation is also in process in relation to the offence which is the subject matter of the trial held by him, inquiry or trial held by him, the magistrate shall stay his proceeding and call for a report in the matter from the police, may club them if the case falls in these circumstances provided by subsection 2 and subsection 3. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. One of the things you must have noticed if you read or if you talk to people around you is that they often refer to something called globalization, or they often say we live in a global world. What does this mean? Today I'll tell you about how to think about globalization or interpret the word global in a sociological manner. When sociologists refer to globalization, they refer to three things. The first is that that it involves transplanetary processes, which means that something is going on across multiple borders, right? The second is that it involves heightened liquidity and interconnected flows. Now, by liquidity, and this is a term that was coined by the sociologist Zygmunt Bauman, we refer to the increasing interconnectedness of things across the globe, but we also refer to increasing instability across the world, which means that potentially something that is occurring many kilometers away from you actually influences the place that you live in. So, if there is a natural disaster happening in one part of the world, maybe that causes people to migrate from that area and they come and settle where you stay. So, that is what we mean by liquidity. And of course, when we are talking about liquidity, we are talking about things that are really moving from one place to the other. Now, the third aspect, and this is something that you may not conventionally come across in the way people use globalization, is that of structures. So, let's take an example. Supposing I, as an Indian citizen, wish to visit a foreign country. Let's say I want to go to South Africa. Can I just pick up my bags and hop on the next plane and go to South Africa. Any logical person is going to say, no, wait, you need to have documents such as your passport or visa. Now, this passport or this visa is a representation of the larger structure that governs how people move across borders. So, we have things like border control, national security agencies that consider what kind of people are going to move from one place to the other. Correct? So, when we think about globalization, an average person typically tends to think about things moving or people moving from place to place. As sociologists, we also consider that there are structures that facilitate or direct this movement across multiple borders. Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. I'm here to tell you a little bit about how we can think about globalization in a sociological manner. Now, one of the important concepts in the field of globalization and particularly global studies is that of global flows. It's a term that was developed by the sociologist and anthropologist Arjun Appadurai. He said that as the world is becoming a more and more global place, you increasingly see the movement of different types of things, both tangible and non-tangible, across multiple national borders. To begin with, you can look at how your day proceeds. I often need a cup of tea to actually start my day. Now, if you think about it, tea that we drink is not something that is that originated in India. It's actually a drink that comes to us from quite far away in China. And this is something that has happened not immediately, but it has happened 400 or 500 years ago. So this kind of movement actually happened with the movement of people. Now, this kind of movement of people and goods is one category of flows that Appadurai talks about. A second category of flows could be financial flows. And a good way to think about this is the kind of volatility that you can see in economic markets today. For instance, in 2008, the whole world experienced a very serious economic jolt. Developments in the country of Iceland had a huge repercussion across many, many countries in the world. Now, that gives you an indication of the kind of financial flows that are a part of globalization. So, we are not only talking about money flowing from place to place, but also financial decisions made in one place having an impact on other parts of the world. Appadurai also argues that there is a third category of flows which he refers to as the flow of images or media. Now, this is something that I'm sure you're quite used to. Much of the programming that you watch on television today, for instance, you may actually be watching channels that have originated or programming that's originated elsewhere. More than that, it could also be that the programming that you see today is influenced by shows that have originated abroad. Similarly, you can have content that was made in India, which makes its way to other places in the world. For instance, we know that Bollywood films are extremely popular in many countries across Africa. So this kind of movement of media is, Appadurai considers it to be an important part of globalization. The fourth category that he talks about is the movement of ideas. So this means that ideas that are popular in one part of the world are not restricted to that part alone, but they actually travel across borders. So, for instance, something that you may read about in the papers would be, say, events such as gay pride events. Now, gay pride events have their origin in places like New York. But the idea that there should be equality between people, irrespective of what their sexual preference is, that is an idea that has now become popular across the world. And so that's the fourth category of flows that he referred to. The fifth category of flows that Appadurai talks about is that of technology. Um, an easy way to think about this is, let's say tomorrow there is news announced that Apple is going to release iPhone 7. As you can anticipate, there is going to be a lot of excitement in many parts of the world, and people are going to start queuing up, waiting for those products to actually come to their country. So, technology is something that is quite exciting and really moves across various national borders. Hi, my name is Gillette Sam, and I teach sociology at IIT Kanpur. Today, I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem. But as a sociologist, you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation. At what age did your grandmother get married? You may find that she got married even younger, 18 or possibly even younger than that. So this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by a biography we can also think of the biography of a particular problem with history. what has happened in the past. How is that connected to this individual or this problem in the present?